All right, I have 5 o'clock. We'll call the meeting to order. Roll call. We have all board members present. We'll go to approval of agenda.
Move to approve the agenda as presented.
I have a motion from Cheryl and a second from Jacob. Any further discussion? Hearing none, all in favor say aye.
Aye.
Opposed say no. Carried. New business. Letter A is the grievance. I'm going to introduce Mick Waldsberger. He'll be assisting us in representing the district this evening. He's gonna open up, lay out some process and ground rules. So Mick, I'll open to you.
Thank you. Again, I'll lay out the ground rules and the process that we'll follow tonight. A teacher in the district has filed a grievance, as you know, and the grievance has advanced to step 3 of the grievance process. The master agreement states that at step 3, the board will meet with the grievant to, quote, review the grievance allegation. So the limited purpose of our meeting here tonight then is to review the grievance allegation. All discussions must relate to and fall within the scope of a grievance, as that term is defined by your master agreement and by Minnesota statute section 122A40 and by arbitral law, meaning arbitration decisions. The master agreement defines a grievance to mean an allegation by an individual teacher or the exclusive representative that a dispute or disagreement has arisen as to the interpretation or application of the terms and conditions of the employment insofar as matters are contained in the agreement. In other words, the master agreement allows a teacher to file a grievance if the teacher believes the district has violated a specific provision of the contract. Minnesota statute section 122A40 subdivision 19 allows a teacher to file a grievance or to utilize the grievance process if the teacher believes that material in his or her file is inaccurate or false. Arbitration law allows a teacher to file a grievance to challenge a directive on the ground that the directive places the teacher at imminent risk of physical bodily harm, or on the ground that it's wholly unreasonable because, for example, it's impossible to comply with. The grievance Ms. Maher has filed, alleges that a non-disciplinary letter of directives, which Principal Holmberg gave to her, contains false and inaccurate information and violates Articles 2, 3, and 5 of the Master Agreement. Accordingly, Ms. Maher or her representative should focus their presentation on identifying the parts of the letter, as modified through the grievance process, that they believe contain false or inaccurate information, on explaining why the information is false and inaccurate, and explaining how the letter violates Articles 2, 3, and 5. If they're challenging any of the directives in the letter, they should explain how the directives place her at imminent risk of physical bodily harm, or why it's impossible for her to comply with them. A grievant may not use this forum to make allegations that are outside the definition of a grievance, and by way of example, claims that a district violated a statute, whether it be federal or state, are outside of the grievance process. The determination has been made to have the meeting in open session. Ms. Maher made that determination, so that's her call. And with that comes some pluses and some minuses. The pluses is that the public as a large can hear the grievance. One of the minuses, though, is that the open meeting law specifically says that school boards may not give preliminary consideration to allegations against an employee in open session unless that employee demands it. So as part of her presentation, Ms. Maher may not make personal attacks or allegations against other employees of the district, otherwise that would violate the open meeting. So, and that should be unnecessary in any event when pursuing one's own grievance. Because we're in open session, again, the public gets to hear the grievance, but the public does not get to make comments, interrupt, or participate in the meeting. And it's important to understand that this is not an evidentiary hearing. This is a review of the grievance process. An evidentiary hearing is where we take testimony, we receive exhibits, and so forth. Because it's not an evidentiary hearing, witness testimony will not be taken or permitted. If the grievant wants an evidentiary hearing, she has that right under the contract to request arbitration. The board has already received all of the grievance paperwork, and therefore it's unnecessary to submit copies of any of that paperwork to the board. Any additional documents that are submitted to the board should relate directly to whether or not the disciplinary letter of directives contains false or inaccurate information or violates Articles 2, 3, or 5. By way of example, character statements are not relevant or helpful in determining whether information is false or inaccurate or whether a violation of the agreement has occurred. And even in arbitration, as a result of that, arbitrators will say they will not give weight to character statements. Ms. Maher and her representative will have a total of 10 minutes to present their grievance to the board, and that should be ample time to identify parts of the letter that are false or inaccurate, to explain why they believe they're false or inaccurate, and to explain why they believe the letter violates the contract. I would note that the master contract allows for presentation by Ms. Maher and or one representative, not by multiple, and even in arbitration, you only get one representative to present for you. So Ms. Maher and her representative may speak, one representative may speak for her. After Ms. Maher and her representative have completed their presentation or 10 minutes have expired, I may ask clarifying questions on behalf of the board, and board members may also ask questions if they have them. After the questions are completed, I will then summarize the administration's position, and I will do so for the board in also less than 10 minutes. And after I've completed my summary, the board will vote on a motion to go into closed session where the board can receive legal advice regarding the pending grievance. So with that, we turn the floor over to Ms. Maher and her representative for their 10 minutes to present on the grievance. And again, the focus should really be on those elements that I discussed.
We respectfully request more than 10 minutes because we weren't told the 10 minutes until just now. We would ask the board if you would allow more than 10 minutes.
I would suggest that that is not necessary, given that there's already been 2 levels of a grievance process that have occurred and documentation in terms of pluses and minuses. It's really not meant to be a public spectacle. It's meant to make your salient points to the board in terms of why you think provisions of the contract were violated and what parts of the letter you think are false or inaccurate. And I'd understand there'd be a lot of dispute in terms of which parts you think there are, particularly after step 2 of the process. So if you get there and you're a minute, you need a minute or 2 more, that's one thing, but certainly to expect a large amount of time more than that, I don't think would be reasonable.
I do respectfully request of the board more than 10 minutes because we were not told this time limit until now. And with the letter being 4 pages long, there's a lot that we have to prove is false and inaccurate. So we have to take each sentence in each piece and show you how it's false and inaccurate. And that's a lot of information to share. In addition, I would respectfully request that we have 2 representatives present because both Connie, Ms. Ludwig, and I have been the representatives for Ms. Maher, both at step 1 and at step 2, and that was allowed, so we had no idea that that wouldn't be allowed at step 3.
You have a request for time?
$25 minutes.
I do think that's an unreasonable amount of time, given the process that we're in. Again, if you needed 15 minutes, kind of thing, a few extra minutes, I think no one's gonna shut you down right at 10, if you wanna go to 15, but I would note that having listened to the recordings of the previous 2, there wasn't a line-by-line statement in the previous 2 grievance hearings where there was an allegation that every sentence was false or inaccurate. And in fact, there was a focus on one particular area, which I believe was addressed at this level 2. If there's some other area that's not been addressed, that was never raised in the previous hearings, which would raise another level of concern for us. So again, I think if 15, that it's a little more than you're, or a little shorter than you're expecting, but that certainly should be ample time to present on this type of matter.
And how about having Ms. Ludwig and I both present? We said we prepared that way, that's how we did it at step 1 and step 2, and we were not notified that that would be different for step 3. So I'm respectfully requesting of the board that none of these parameters were given to us until just now.
And these are sort of legal parameters, when you go to an arbitration hearing, you don't walk in and say, well, nobody told me I couldn't have 2 people presenting. It's understood that one person is your representative.
Respectfully, this isn't an arbitration.
Understood, I understand that as well, but at the same time, when you get to a formal board level process, many of those same rules apply. So is it not possible for you to present it, one of you to present both parts of it?
It really would be extremely difficult.
I'm okay with it.
Okay, thank you. Okay.
Good evening, everyone. I want to thank the board for this meeting tonight, and I want to thank everyone else for showing up and showing their support tonight for Tammy. I'd also like to thank Tammy's parents for the great t-shirts, but for the staff to show our support for Tammy. I'm Connie Ludwig. I'm the members' rights advocate for the Paynesville Teachers Union. Tammy contacted me about her medical emergency the day after she left school to inform me of her FMLA, and I've been working with her for the past 4 months on all the issues that have come up. This is Carrie Rerhauer. She is the Education Minnesota Union representative. While Carrie is presenting, I'll be passing out the papers that she will be referring to.
Thank you, Connie. Good evening, board. I'd like to start, as she gets those passed out, to have you please find the letters in your packet that were hand delivered to Mrs. Tammy Maher, dated November 29th, 2021, from Mary Holberg with directives. And also the one dated January 17th from Ms. Bullard. These letters contain false and inaccurate information. The first letter is the original that was presented to Mrs. Maher. The second one is the edited version after our step 2 grievance hearing. And you can see on the letter dated January 17th what was crossed out after the step 2 grievance process. We have highlighted for you the false and inaccurate information that still remains in the letters. Therefore, per Minnesota state statute, we are asking you to expunge the letter from Mrs. Maher's file and rescind the directive stated in the letter immediately. The letter states on October 15th, you requested a medical leave of absence. At the same time, you provided a one-page substitute teaching outline for October 15th. You didn't provide any other lesson plans or materials for the substitute. Upon investigation, the district found that you had not prepared materials or lessons for students beyond October 15th. We want to clarify that providing lesson plans while on an FMLA leave would not be a requirement. It was an emergency medical situation and not a planned absence. Therefore, Mrs. Maher should not have been expected to have lesson plans out for a substitute. In addition, Mrs. Holmberg could have asked the other 3rd grade teachers for plans and they would have provided them. Just like Mrs. Maher has previously provided plans for Mrs. Lakeville. The letter also states the following, and I'm going to read a number of quotes to you. You exited the building without permission, without notifying me or anyone in the office. You did not attempt to contact me. You did not return my calls. You left the building without informing anyone, without informing me or anyone in the office. After the incident, I informed you you must notify me if you leave the building and must report your absence. You plan to comply with my verbal directives given during our September 14th meeting, and you did not notify me or the office. We would like to state an employee should not be required to get permission nor notify the office when experiencing an incapacitating medical emergency. In addition, the letter states, after receiving the voice message, you reached out to your teammates and then continued to encourage them not to reach out to me. This is false. Mrs. Maher did not ever nor continue to encourage teammates not to reach out to her administration. We asked at the grievance step 1 meeting for the names of the teammates that were referenced, and the response from administration were that they were Mr. Hess and Mrs. Lightful. We have since found out that these teachers were never interviewed by the district or by administration. Therefore, administration has no statement from them. We do have their statements, however, and I will give you a copy of those. They have included in their statements for you that this is not true. As she's looking for them, I will read the important sections. So in the letter from Mr. Hess, it says, I was going to contact Mary and bring the events to her attention per her request after the spring incident. So this is the principal. So I called her and asked her to come down. When Mary came, I shared the events as stated above with her and asked her not to contact Tammy right away. As it is school stuff people that seems to be her trigger, I asked Mary to please wait until she hears from Tammy first. This was the whole request from me. At no time did Tammy ever tell me not to let anyone know about the event. She couldn't even make a full sentence, let alone give direction about how I should deal with it. That is in starting on the 4th paragraph now. what I just read. Then I'll refer you to the letter from Mrs. Lakeville. Halfway through the first paragraph there, it says, Tammy Maher has never instructed me not to tell Mary Holmberg that she left work, nor has she instructed me not to tell Mary anything. And then I'll read the very last paragraph. I have never had a formal interview or been asked any of the above information by administration of what happened the day of Mrs. Maher's medical emergency on October 14th. All of the accusations that use my name are false. I never said any of those words or have been asked about any of these situations. I will then refer you to the copy of the text message Mrs. Maher sent later that evening. About halfway down after the sorry with the 3 exclamation points. Her text says, Mary called Corey. He said he just replied I'm being taken care of, so clearly she's aware I'm not there. So whoever took care of letting someone know, thank you, exclamation point. Who is helping my class? They can work on their Frankenstein writings this afternoon. The text message shows Mrs. Maher is thanking the individual for letting someone, and Mary, her principal, know. Since Mary is stated in the sentence right before this, it's clearly being thankful that Mary knows. This shows Mrs. Maher was not trying to deceive anyone. She was communicating as best she could at the time. Hard to understand why she would be glad administration knew what was going on if she was trying to somehow sneak out the door. Even after the horrible experience of the severe panic attack she had, she was still thinking about her kiddos and their Frankenstein's writings. This is a teacher who truly cares. It is also important to note here, even if Mrs. Maher had said what she was alleged to have stated, that given her medical condition at the time, any communication during that incident shouldn't be held against her. Again, however, we reaffirm she did not say those things. Now we will show you 4 things. First, we will show you the evidence that this was indeed a medical emergency. A panic attack has true physical symptoms. Mental health should be treated no differently than physical health. The big difference is that there is still misunderstanding about mental health. A person can look perfectly fine on the outside, leading to many misconceptions. Unfortunately, this was not treated as if it was a medical emergency. So take a look, we have the medical notes from the doctor. Second, we will show you evidence that Mrs. Maher is being required to do much more work than and has more restrictions placed on her than other teachers since returning from her FMLA. We will also show you that she has received an ongoing inordinate amount of oversight on behalf of the administration that no one else in the building has. In addition, administration has restricted Mrs. Maher from collaborating with her coworkers, which goes against the philosophy of the district and the known best practices.
Okay, on this one, I'm passing out, these are the top 2 pages show you what just a classroom teacher does for lesson planning. So that's the first 2 pages there. The next 25 pages is what Tammy has to do for 1 week. And then behind that, behind her lesson plans, you'll find the emails from Mary Holmberg clarifying all the lesson plans that she goes through, asking questions of Mrs. Maher. And finally, at the very end of this packet, you'll find a letter that has just one part highlighted. And it says, I've been informed the other teachers have been writing some or all of your lesson plans for you as a means of support. This information was shared with very vocal displeasure about the added workload in an open forum with multiple staff members present. To be clear, you must prepare your lesson plans for your class.
Third, we will show you evidence that Mrs. Maher in 13 years of teaching has never had an issue with her lesson planning for organization or substitute plans left for a planned absence. In fact, she was diagnosed with a mental illness 15 years ago and has successfully managed that mental illness and excelled in her teaching all of this time. In fact, she was nominated and won the first trophy for the PBIS Award of Excellence and completed digital curriculum writing and was paid by the district to do this. Thus, most of her lesson plans are in a digital format. Therefore, there's no reason that we can find for her to be required to do the extensive amount of extra work being required of her currently.
All right, the last packet that was just passed out, the top sheet of this packet is an observation result that is in Tammy's employee file. This observation was conducted by Mary Holmberg herself on December 14th of 2020. So not this past December, but a year ago. The sheet indicated that Mary saw all the evidence of good teaching happening in this classroom. She rated Tammy on the scale as applying, which is almost the highest score. If you flip that paper over, you will see Mary's personal comments about this observation. She says, and I quote, "Mrs. Maher's classroom is highly organized. Students' expectations are clear as they are empowered to share their thoughts and ideas with classmates in a non-threatening manner. This lesson was effectively scaffolded. It was building upon prior knowledge to practice story elements in an I do, we do, you do scenario. Behind this observation, you'll find many letters of support from former and current teachers, some who have even subbed in Tammy's classroom."
And fourth, we will show you evidence in just a minute after my closing that she is not the only employee to ever have had an unexpected absence. However, she has been treated differently than the other employees that have had unexpected absences in the past. In my summary, we have never seen anyone treated this way. For a health emergency, the first step should have been a conversation with Mrs. Maher for support and how to return and how that support could be provided upon return, but that didn't happen. Instead, at the first meeting, she was blindsided with a 4-page letter of directives that was premised on incorrect information.
Well, I'm gonna sit, is that okay if I sit?
Yeah.
Okay, so I am going to share through my lens, this experience. So I think, that is just as valuable as these facts that you are pointing out, that they've been pointing out that directly we're providing that is false. I think it's just as important you hear how this has affected me and my family and my friends. So first off, I want to thank you all who helped get this grievance heard tonight. The superintendent had stated this hearing would happen on the 22nd, the night of parent-teacher conferences, not February 8th, the night the union had asked for to be held. I did not want to miss the opportunity to meet with the students and families. Having it changed has provided me some hope that this will come to an end. I've always admired those that could speak so freely about their mental health journey. I knew I would never have the courage to be a vocal advocate. But that after you become a survivor of mental health, you have a duty to pay it forward. A voice that for those that have not survived. I had become a silent supporter for mental health. I would never deny my diagnosis, but I had no plans of openly sharing it. I have reached out to many through the years, privately sharing my journey with them, as many people did the same for me over the years. So Connie will share, is it my story there? I kind of go through, yep, so I can kind of skip through some stuff. But I shared my story and my experience last spring with Mrs. Bullard, myself, and with Mrs. Holmberg. I had coffee with Mrs. Bullard afterwards. I had a follow-up conversation with Mrs. Holmberg in the fall about it. You know, let's see. So during that meeting, I did share when I was with Mrs. Holmberg, I did share with her things that caused me extra anxiety at school, and I actually called that meeting. At no point during this meeting did she give me any verbal directive she is claiming to have given me, nor did I stop communicating with her. I asked for the meeting, therefore it was not disciplinary, nor were there directives given at the meeting, which, you know, brings us to where we are today. So you've obviously been shown now through many documents that I had a medical emergency, my coworker drove me home, or I had more medication to take. I think if you take a look at that text that you handed out, right? I think an important thing to note is that the only thing that was zeroed in on that text was that I did not notate Mary. The whole text is about my medical emergency, and that was never even a addressed, or there was no compassion or no anything about that. The only thing out of that text that Mrs. Holmberg could find out what was wrong with that is that I said someone and not her name again. I think that's important that you carefully look at that. The district has not cooperated with my union representative nor my doctor's requests. My union has tried to step in for me since the beginning to help with communication so I could recover. I sent the necessary legal authorization on October 27th, 2021 for Carrie Ruhauer, my union representative, to speak to the district on my behalf while I was on FMLA. The district, however, has continued to send communications directly to me rather than my representatives throughout this process. On October 14th, Dr. Youngs asked for me to be fully removed from work and contact her with any questions. My psychiatrist asked the district to contact him with any questions. At both grievance hearings, Carrie and Connie have intimated the district is causing me more anxiety and stress, and to not continue to reach out to me directly. In addition, on several occasions, the district expected me to come in for a meeting while on FML leave, and also to immediately respond to my work emails while out on.
I want to interject because we need to know that, again, the basis of the grievance is violation of the contract. So speak to which contract provisions were violated and why. Whether the directive is wholly unreasonable.
Oh, sure, want me to skip that page?
And, those are the points, you know, on the false and inaccurate, but the general information is not part of the grievance.
So the part that we're talking about though is the permission. No one has to have a permission to have a medical emergency. So do you want me to go more in depth with that?
But that, again, you're left without permission. It's not saying you had to have permission to have a medical emergency. And you didn't say it was untrue that you left without permission. You said that you shouldn't have to have permission for a medical emergency is what was stated.
Start? Okay. So what does it feel like to have during a panic attack? And what makes one so terrified?
Again, how does that go to the contract, which violation or which provision of the contract was violated and how? Whether the directive was unreasonable, a specific directive you received. Those are the things we're looking for.
The depth of these lesson plans right here. The depth of these lesson plans feels like asking someone in a wheelchair to build their ramp, back up to work, continue to work there. Not only that, build your own ramp to their specifications, and when you are working on it alone, you must make sure to put forth a great attitude and greet me every day with a smile. Even if if I tear down a few pieces after you leave because I didn't think they were quite up to par. It's like telling a custodian, yep, you clean the school as part of your job description, but now you will clean it with a Q-tip. I will then come around with a white glove and inspect every corner, and there better be no sign of any residue on my white gloves. An electrician wires homes, but not by themselves in one day, and a mechanic works on cars, but does not tear out an engine and rebuild it in one day. These directives do not raise me up and help provide me with continuous quality instructions for my students. Instead, they add a large amount of workload that is unnecessary and doesn't allow for the flexibility needed for quality teaching. The odd thing is though that after this keeps dragging out, it actually hasn't worn me down. It has actually made me stronger. I have cried a little bit less. Let's see where else I want to say. I think I'd like to point out that actually there has still been no talk or no plan about how to help deal with my medical needs at work. So if there is a need for a 4-page directive, it might be how to keep me and my health number one. 2. Let's see. Again, no other teacher in the building is required to send weekly substitute lesson plans for each subject taught, 5 for me, in the depth comparable to those of a college student taking Education 101. I'm still actually confused if the plans are for a sub or for administration. These plans also need to be emailed by 4 p.m. on Friday. I then return every Monday morning to her thorough critique of each lesson and subject. I actually have highlighted some of those in your packet that you have. They are expecting me to do all of this, plus my regular duty as a general education teacher, just to keep my job. I've asked them how long. Did you pass out that to her? I asked those directive questions? Because I asked how long this is being required, that I have to do this, and how they're evaluating them. They have not ever answered that. I've also been informed to follow my directive should take precedence over my prep time versus meeting the needs of some of my most vulnerable students. I have even been told I have to directly ask Mrs. Holmberg to leave the school grounds. No other teacher has to do that. The expectation by the administration is that during my medical emergency, I should have ran back to my desk in front of my students, tidy up my materials for the rest of the day, request a sub by logging into our substitute platform, fill out all the information needed to get me a sub for the day, make substitute plans for the rest of the day, because I had plans for the day, but they would not be in detail for a substitute, as I was not planning on having a substitute for that day. And also make sub plans for an unforeseen amount of time, because of course I didn't know that I was not returning to work. And then most importantly, ask my principal for permission to leave the building and seek medical help. This expectation of them, really, or for anyone in a crisis or state of emergency is incomprehensible.
You had pushed up on your time. Can you give a closing sentence or two to, you're well over the time here.
Okay, so the last thing I want to say is I hope you keep in mind that Tammy's not asking for a raise. She's not asking for special accommodations. She's not asking for anything. She simply wants to have her job returned to the one that she has been doing for the past 12 years. One where she is in control of her teaching, she lets her be creative in that process, taking cues from her students to guide her instruction. That is all she's asking for.
Thank you for your presentation. I'll just now briefly provide just a very short statement of the administration's position on the grievance. The administration believes that the grievance should be denied, and you know most of the facts, but just let me review some of the basic ones. First of all, in May of 2021, Ms. Maher felt ill while teaching during the school day and asked her colleagues to assist her in leaving the school building. She left the building, again, without informing Principal Holmberg or anyone else in the office. After that incident, so the May incident, Principal Holmberg directed her to notify her if she left the building. In October, specifically on October 14 of 2021, Ms. Maher again felt ill and left the building. She informed colleagues she was leaving, but she didn't inform the principal. She didn't inform anybody in the office she was leaving. After she left the building, it's undisputed, she sat in the parking lot for an extended period of time. She stated she was attempting to call her husband. She never attempted to call Principal Holmberg. We also know she was texting throughout that day. She never got back to Principal Holmberg, never texted, never tried to make any kind of contact. Two teachers subsequently notified Principal Holmberg that Ms. Maher had instructed them not to inform her about her departure. They also shared that they were concerned about Ms. Maher's well-being and about the supervision of her students. Ms. Holmberg then attempted to contact Ms. Maher. Ms. Maher did not answer her phone or return any of the calls. I want you to know too, that right after that happened, Principal Holmberg contacts Superintendent Ballard and shares that information at that point in time. So when the facts are fresh, when no one's put pressure on anybody, and there's certainly no reason for Principal Holmberg to provide any inaccurate information. She's sharing right after it happened, what happened to her supervisor. She has no motive to go out and harm anybody. The next day, October 15th, Ms. Maher requested a leave of absence. When Principal Holmberg reviewed Ms. Maher's subfolder, she found only two documents, a schedule and a class list. The subfolder did not identify any activities that had taken place the previous week or any instruction or activities that were planned for the following week. Principal Holmberg also discovered that Ms. Maher did not have any lesson plans, online lessons, platforms, or materials in place or available for Thursday, October 14, Friday, October 15, or the week of October 18. In short, there are no plans, no instructional framework to guide Ms. Maher's instruction or the instruction of a substitute teacher. And we've heard that, well, Ms. Maher didn't plan, she wasn't planning to be out. That's exactly why we plan ahead, why we have substitute folders and why we do lesson plans in advance. So when we're absent unexpectedly, the kids aren't lost and left without continuity of instruction and to suffer because of the lack of planning. When Ms. Maher returned from her leave of absence, Superintendent Bullard and Principal Holmberg met with her to discuss the failure to comply with the directive to notify Principal Holmberg before leaving the building, the failure to report the absence through the time management system, not even only just right then, but even for an extended period of time after she was gone, and then her failure to prepare the lesson plans. After the meeting, Ms. Holmberg and Ms. Maher gave a Principal Holmberg gave Ms. Maher a non-disciplinary letter of directives documenting the information. We then had the grievance filed and a number of statements went back and forth. You've heard statements about these teachers not being interviewed. They weren't formally interviewed as part of an investigation because they approached Principal Holmberg and shared that information with her. And now they say something different when there's been pressure exerted upon them and there's a room full of people with expectations. The directives in terms of lesson plans, you know, there's the statement that continues to be made despite the fact that both Principal Holmberg and Superintendent Bullard twice told the grievant, there's never an expectation for you to do lesson plans while you're out on leave. The expectation is that you would have done them in advance, so if you're unexpectedly gone, kids don't suffer because of that, so that the substitute knows what to do. And in this case, Principal Holmberg actually wrote the lesson plans herself. She had to go back and do them herself. And I'd ask people to stay quiet, be respectful of the forum as well. I'm certainly under, they had 20 some and I'm at 6, please, so please do not interrupt me again. The statements on the lesson plans, I want you to know it's entirely reasonable as a matter of law and practice to require a teacher to prepare lesson plans. That's part of being a teacher, and to require them in advance. And while Ms. Holmberg required some specificity, she had good reasons for doing so. On two occasions, she found that lesson plans were not done, and she wanted to make sure that meaningful plans would be completed. She wanted to make sure that they would demonstrate systematic, structured, standard-based, differentiated instruction. If any teacher tells me that they don't think they should have to provide systematic, structured, standard-based, differentiated instruction, I'm going to be concerned about the quality of instruction provided by that teacher. You heard statements, the information that was presented was about inaccuracies with respect to whether or not Ms. Maher told other teachers that they shouldn't tell the principal she was gone. Ms. Bullard tried to address that at step 2 of the grievance process. Basically said, this isn't worth fighting about, it's not worth pinning staff against a building principal, I want to move the process forward, and agreed to eliminate that language that they stated was inaccurate. So that shouldn't even be at issue. They did point out to one sentence in the second paragraph says, after receiving my voice message, you reached out to teammates and continued to encourage them not to reach out to me. I think in fairness, that statement was meant to be taken out by Superintendent Bullard as well, and wasn't. But that eliminates that whole issue altogether. There are no other statements there that were actually identified as being inaccurate. The statements were, for example, that in the letter that shortly before 9:20 a.m. you left your classroom without permission. That's factual. That's accurate. She's saying she shouldn't have had to get permission. But it's factual and accurate. It's correct what is stated in the letter. You informed your colleagues that you were leaving. That's factual. It's correct. Nothing inaccurate about that. So again, we haven't heard actual information about what was false. And I would note as well, we've heard no information whatsoever about the articles in the contract that were allegedly violated. There's no information that suggests that any article in the contract was actually violated in any respect. again, she wasn't required to do lesson plans on a leave of absence. She was required to do them so they'd be available for someone in the event that she was absent, without advance notice. And all teachers should do that. I'd also add that, as Principal Holmberg has stated in her letter, her expectation is that all staff do lesson plans. And that expectation is recorded in the staff handbook. And if staff aren't doing that, that's something we should look at altogether for all staff, because certainly that's something that staff should be doing. For her to turn around and then ask other employees to do her lesson plans, it raises another concern. This should not be hard for an experienced teacher to write appropriate quality lesson plans. The statement was made that making her, Ms. Maher, prepare lesson plans feels like requiring a person in a wheelchair to build a ramp, or telling a custodian to clean with a Q-tip. The better analogy is to say, it's like telling a custodian who is not cleaning a part of the building at all, that the custodian needs to clean that part of the building. You can't complain about being required to do something that you should have been doing in the first instance all along. Lesson plans are part and parcel of being an instructor. And the Minnesota Supreme Court has acknowledged in case law that it is within the authority of administration to direct and require lesson plans. I'm not the expert in what a good lesson plan should have in it for elementary kids. I can't speak for Ms. Ballard whether she is or not, but it doesn't really matter. We do know who the expert is, and that's your building principal. She has that right to establish expectations of what she thinks quality lesson plans should include. Lastly, I want to address, on behalf of the administration, the misstatements about what is expected of Ms. Maher if she does have to be absent in the future unexpectedly. Because it suggested that she'd have to do things and that we're treating her differently than any person with a physical disability, and that's just not true. All you have to do is read the directives that were actually given to her on page 2. The directives say if you need to leave the building for any reason during your duty day, you must notify me immediately unless you are physically incapacitated and unable to do so. Panic attack would qualify for that. You must first attempt to notify me in person or by phone. She's out in the parking lot calling people. She could have called her principal as well. If you're unable to reach me in person or by phone, you may send me an email. Could have done that from a smartphone. After notification, you must reach out to a licensed colleague to cover your class. Can't just tell a paraprofessional or someone else, hey, cover my class for me. And I wanted to make this point too. In any line of business, can you imagine in any line of business where you get to just say, you're an employee, I'm leaving, and not tell anybody in authority you're leaving? What business runs that way? And isn't it even more important when you're charged with supervising young children? Someone in authority. The next expectation is that if the principal is absent from the building, you can notify the superintendent. If your physical condition prevents you from notifying immediately, you have to notify me as soon as you're able to do so. So it's not a black and white, you must do X. It is as soon as you're able to do so. That was our concern, that as soon as she was able to do so, she didn't report the absence. So without belaboring the points, on behalf of the administration believes that the grievance should be denied.
I would
And a
request,
heart attack would be treated the same way?
I would request to just rebut a few things that he said, if I could have a minute, because they were quite heavy.
That would not be the typical process. I think that at this time, the board would have the option to move to closed session. You may hear it if you want. It's up to the board. It would not typically be the process, because what happens then is this rebuttal, then I'm going to want an opportunity to rebut, and we go back and forth. Each side has an opportunity to present its position. And again, this is the position of the administration as documented through the letters that were said, exchanged.
Do they have the letter that they sent me in the mail over my leave?
I would just request 1 minute to rebut a few of the things that he said. They were quite emotional and heavy, and I would like the opportunity to say a couple of things.
I'll give you 1 minute, but then we'll
Okay.
take 1 minute.
All right.
It can be about as well, please.
When he talked about the saying that the directives require that, that's not what we were referring to. We were referring to that the letter says that she should have not left without permission. Shouldn't have left without informing anyone in the office. She should have put it in the absence time management system, and this was during the emergency. So we're saying that was the expectation during this emergency, and it's right in the letter. And then the other one was
Can I ask a question, then does the
Yeah.
letter state, how soon after, or like it just states to do it, is that accurate? Doesn't state immediately,
it doesn't say immediately.
okay, thank you.
Okay, and then the other one, she's never put any pressure on any other teachers to provide these statements. In fact, Mrs. Maher has not asked anyone to do these, only other representatives.
Has the union asked teachers to do that?
No.
Has the union gone around and asked teachers to complete statements?
Other representatives asked if they would like to.
Thank you.
There's no pressure. And then she has offered at both level 1 and level 2 steps to do an emergency subtub of a whole week to have available for a week's worth of lessons for that classroom. But it would have to be general, because otherwise you'd have to create it every week. That was not accepted. And then she also just asked to have the same requirements that all the other teachers have, to fill out her lesson plan book, the same as all the other teachers.
Okay, and we're at.
And then she did not ask other colleagues for permission or for help leaving.
We're at
She
that now.
was out, if you just read Bill's letter, she couldn't make a full sentence
Okay.
at the time.
District having a response?
Thank you.
Board can, if it,
I would like to know, Tammy, at what time, did you seek medical help the day of the incident? And at that time, what was your doctor's directive for the medical leave process?
To be removed immediately
From work.
from work.
and so you were able to call your doctor and talk to your doctor that day?
Okay.
Don't answer.
Well, I wanna, I mean, did you have any
Totally out of line. Yeah, out of
time?
line.
We need to have a stop on that.
You have a medical doctor
This
say.
time.
Shut up. Out of line.
Contact Principal Holmberg that same day.
I am
You
sorry.
don't need it.
Did you
No,
contact?
don't answer that, don't answer that. Actually, keep asking the medical questions. Why don't you ask me some more?
Closed session.
Yeah, I don't think you can ask medical questions. You
A motion
can't ask
from Rick.
medical questions.
A second from Bruce, any further discussion? Hearing none, all in favor say aye. Aye. Opposed say no, carried.